So hello everyone and welcome back to our tutorial recording. So just a brief note on how we're going to structure these tutorials moving forward. You will note that our study schedule has only 10 weeks. So this is intentional. So it's the same 10 weeks I give whether it is in semester 2 or in the summer school. So always 10 weeks. But in your case, after 10 weeks, you'll have a 2-week break, which means that you have everything you need before you go to the final exam. But even when you come back and I issue you with your exam briefing, we're going to have 3 weeks together working on problem-solving questions to even make you more prepared for part B of the exam. Until we get there, every week we're going to have a tutorial that's going to be broken between Toowoomba and Springfield. So part of it is going to be given in Toowoomba, part of it is going to be given in Springfield. So this week we're going to cover stuff on chapters 1 and 3. If you look at the tutorial questions for chapters 1 and 3, you'll find that they are mostly about legal knowledge. So I'm not going to cover them in class. Instead, we're going to start working on our Wentworth-Miller method and the ILAC method in preparation for the problem-solving questions we're going to see when we go to the substantive areas such as criminal law and tort law and contracts, and we end up with agency. We will end with agency. Again, this is what I want from you. Okay? All of this tutorial, the whole series, is really to get you to identify the legal issues. And where are you going to find the legal issues? Legal issues come from where? From our earlier discussion, we said that you need two things. What is the first thing you need that relates to the theory? So I spent 2 hours with you already. Okay, 2 hours talking about that thing. All right. Let's start with this gentleman here. What's the first thing you need in order for you to identify the legal issues?
The elements.
Okay, someone says the elements. Do you agree?
Yeah.
Okay. What else other than the elements you need? You have to look at the elements and the facts. Okay? Legal issues will come from looking at the elements and the facts. So, we looked at what? We looked at our definition of law. Remember the definition of law? And we said it has 4 what? Elements. And we said we are going to look at an example like what? Like rugby union rules. And those are what? Our facts. And from looking at the facts on the elements, you can see where the legal issues are, i.e. where there's tension. We're not sure whether this element is made or not. Okay, so let's look at that in the context of the Wentworth-Miller method. Today we're not going to really cover any legal theories, it's just week 1. But we're going to start you on this Wentworth-Miller method. So what do you do? So this is just like programming, really. It's like math. You'll do it every time you look at a problem-solving question. In fact, you can use it when you look at anything. Any problem, anything that requires analysis, you can start by looking at it this way. The first thing is to identify the parties to the conflict. So something happened between 2 parties or more, and because of what happened, there's conflict. One party wants something and the other party wants something else. Then you have to identify their objectives. Like what? Do they want money? Okay. Do they want someone to follow through with the promises they made to them under a contract? Do they want to punish someone? Do they want to send someone to prison? That's what we mean by objectives. What do you want? What do you want? Then identify the legal premises and counter premises. also known as legal cause of action or legal theory. For example, negligence. Negligence would be a premise. We call it a premise. A counter premise would be a defense to negligence. So you are trying to attack the person, the defendant. Defendant will push back by saying, in fact, there is a counter premise. So I have a defense, like contributory negligence or voluntary assumption of risk. We'll talk about that in more detail. But this is what we mean by premise and counter premise. Once you identify the premise, you can identify the elements. So if I know that they want to, it's just like game theory. If they want to do something like negligence, then I know that negligence, when we study negligence, has three elements. A duty of care, the existence of a duty of care on the defendant to the plaintiff, a breach of that duty by the defendant, and causing harm, i.e. it could be physical injury or it could be economic loss caused by the defendant to the plaintiff. Those are the three elements. In those three elements, you'll find that there are legal issues. How would you know? From the facts. So when I give you more facts, or you ask me for more facts, if I'm, for example, reporting something to the police, as I do so, it becomes clearer and clearer that that's not an issue, this is an issue. Okay? So once you get the issue, then we're now ready to start with ILAC. So, for the purposes of your final exam, so for the assignment, it's going to be a very, very, very simple version of this. I'll take you through the assignment next week. Go through examples, and as I said, please go online and download your two scenarios now. Okay. In the exam, I don't expect you to write anything about this. All of this is in your head. This is what we call planning. I don't expect you to write anything about this. The money, the marks, start from ILAC. But to get to ILAC, you have to know the legal issue. To know the legal issue, you have to know the elements. To know the elements, you have to know the premise. To know the premise, you have to know the objectives, and you have to know the parties. Once you spot the legal issue, just go ahead and start writing. What is the issue? What's the relevant law? And then apply it to the facts and conclude. There could be more than, of course, one legal issue per question. And as I said, if we're successful, we will get you hopefully an open book exam. So you don't have to memorize anything. So you can have your notes or you can have your book, whatever, and take it with you to the exam. And failing that, we'll have a plan B of having a cheat sheet where you will get the relevant law for the one or two questions you will get in part B. So I'll give you the law because you don't need to memorize it. So that means you will get the theories, you'll get the summaries for the cases, and so on. So all you have then to do is to spot the issue. And if you don't spot the issue, you will fail that question. Okay? If you don't spot the issues, you're going to fail that question. All right, so let's look at this Wentworth-Miller in more detail. Today, we're going to focus on step one. Step one is to identify the parties to the conflict and the objectives of each party. Step two is to look at the premises. So this is the legal theory. Step three is to identify the legal issues that arise from these elements based on the facts. Okay? So let's get an example. Let's look at an example and see how it applies. So we say A. So when I say A, it could be any person, right? Bob or John or whomever. A. Driving his car with passenger B. So A is driving his car with passenger B. Approaches and enters an intersection with the green light. Although green for A, the light flickers yellow for C. approaching swiftly from A's right. So there's a car with A and B, okay, green light, and C is approaching from the right. The two cars collide. So this is the genesis of the conflict. So they collide in the intersection, injuring the occupants. Simultaneously, D drives into the intersection from the direction opposite A. She swerves to avoid the collision between A and C, and in so doing strikes pedestrian E, who had just stepped off the curb with a walk sign. Do you see? A and B in the car, C is coming from the right, they collide, D is coming from the other side, and there's a pedestrian crossing, and they collide with them. So you need to visualize. B, meanwhile, who's the passenger, leaps from A's car and in a rage slugs C, breaking his nose. All right, that's all we have. What is this? This scenario is giving you what? Facts. Every sentence, every word, every paragraph is giving you facts. So when you do your exam questions, you need to make sure you're using every fact. That's what you will get. This is your scenario. Now, so A, driving his car with passenger B, approaches and enters an intersection with the green light. Although green for A, the light flickers yellow for C, approaching swiftly from A's right. The two cars collide in the intersection, injuring the occupants. Simultaneously, D drives into the intersection from the direction opposite A. She swerves to avoid the collision between A and C, and in so doing, strikes pedestrian E, who had just stepped off the curb with a walk sign. Meanwhile, B leaps from A's car and in a rage slugs C, breaking his nose. All right. So, when we say we want to identify the parties, what we mean by that is the movement. In other words, whom do you think out of A, B, C, D, and E might think of going to court? Why would they go to court? Because they think they have a cause of action that they could win on. So there's something they want. So you go to court to get that something you want. Okay. Can someone give me the pairs? Whom do you think would go to court? Someone says A. A is going to go to court against C. Someone says A. Someone says A versus C. Mary, why do you think A is going to go to court against C? What is their objective? So why does A want to take C to court? Hit his car. So what is his objective? What does A want? Compensation. Okay? Do they want punishment? Not really. They want compensation, right? Of course, there's this issue with CTP and the issue with insurance. We're going to leave that aside for now. Just let's focus on who wants to take whom to court. Okay. Who else?
D versus A.
Okay. Someone says D could take D versus E.
Well, A can take D to court.
So let's look at first D versus E. Remember, D is the person who was coming from the other side, and she hit the pedestrian, E. D is going to take E to court. Okay, so you think it's more reasonable that E is going to take D to court. Great. So now we're thinking, which is good. Okay, so I will just say E and D. We'll just cross it and say E and D. So why would E want to take D to court? She ran him over and he wants money.
Depending on what the person wants.
Okay, you might actually simply want, or you could both. You could want both, right? You could actually take a person to court because you want them to be punished, but you also want compensation. What else? So one person at a time, please. So C versus B. Okay, C is the guy coming from the right, and versus B. So when I start with the person, it means they are the movement. They are the ones who are going to go to court or to the police. Why would C go against B? Okay. So now we are starting to identify the premise. Do you see that? We're not just saying that C is going to take B to court, but we also know that C wants to punish B and maybe get some compensation. But we also know that their premise, what they're thinking of, is assault. What is it that you still don't know? That's law. It's very simple. Once you know the elements, you can argue. Remember, arguments are always about facts. You never argue about the law. Yes?
The traffic lights, that's the main point. Couldn't we actually take the council to court? The traffic lights can't actually.
So let's just start by talking about assault. What is it that you miss? What is it that you don't know? Yeah, so some of the facts. But what is it that you don't know? You don't know. You know the facts? So thank you for that. In your exams, don't introduce facts not given to you. Use the facts that are given to you. If you need to make assumptions, make sure you make your assumptions explicitly. Don't go and say, I don't know the extent of the injuries, so I don't know whether there was assault or not. We said that someone was injured, so we're telling you, go there. Go and talk about assault. But what you don't know is the elements. You have the facts, what's missing is the elements. And that's what we will be studying together. By the end of this 10-week process, you need to know the elements of certain causes of action from some substantive areas of law. Things like torts, like negligence, okay, or defamation, or criminal law, like assault, or contracts, okay, or agency, and so on. So I'm not going to teach, of course, the whole law and every element of every cause of action, but once you've done this course, you can do that on your own. Because you know what you're looking for now. All right, C and B. What else? B versus D. D versus okay. So give me one, please. What do you want? And C? D versus C. So D is the guy that was coming from the right, and C is the female that was coming from the opposite side. Okay. Okay. So D versus E.
The D saying that if the car crash in front of him wouldn't have happened, then he would have swerved and hit the pedestrian. So the car coming in, avoiding the collision, is wanting to do the people who were in collision.
Okay. So which car was coming from the other side?
D.
C.
No, C.
No,
A
C
coming
is
this way,
D.
B's coming
Yeah,
this way,
D.
C's coming this way.
And D versus E.
Yeah.
So you want D to sue E, saying.
C is the pedestrian. C is the car.
So you want. So is this the entry we're talking about?
Yeah, so D versus A and C, I suppose. C.
So D versus A and C. So the cars, because of the collision. Had not the collision happened, she wouldn't have hit the pedestrian. So, okay. What kind of premise would you use in here? What legal theory could D raise to go after A and C? Okay, thanks so much. What's your name?
Damien.
Damien says maybe we can use negligence. So, had it not been for the negligence of A and C getting into this accident, I wouldn't have hit E. But for your conflict, i.e. the accident, I wouldn't have hit E. This is the skill you need to pick up from this course. When you see some facts, you could go, oh, this looks like this. So you can identify the premise. Is that enough? Then you have to identify the elements. You memorize these. Then you have to project the facts on the elements to see if really you have a chance proving negligence. Because if you fail on any of these elements, you will not prove negligence. What else? B versus C. So B was the passenger and C was the guy that came and hit the car. Right? What kind of premise B is going to try to use? What legal theory?
It did say that people were injured in the car, from the car accident, so he may be one of those people. So it could be medical issues or also compensation that way.
So what would you argue in front of the judge? What kind of cause of action you're going to put your claim under? Negligence. Okay? So you're asking for money, not punishment. You want money. What else? Now, what's your name again? Danaka. So I always forget, sorry. Why did you refer to the council? What was the point there?
Because the traffic, it said the traffic light was running A and then C coming in, the traffic light flickered yellow. That
So-
seems to me that the traffic lights were faulty because all four traffic lights have to go red for 3 seconds before one goes green.
So let's just go through that, unpack it a little bit more. You said maybe the council is involved because of one of the facts. And the fact is telling us what?
That the traffic lights may be faulty.
Yeah. So let's go back to the facts. So which facts are we talking about here? So it says A, driving his car with passenger B, approaches and enters an intersection with green light. Anything there? No. Although, that's the first sentence, although green for A, the light flickers yellow for C. So I see green, but he sees yellow.
So he was seeing green, then it flickered yellow. So it's saying that both opposite directions were green at the same time for a second. That's not correct. So that's
Is that what I say there?
no. I was just saying that's what thing before.
So what would you do in an exam situation at least?
Saying that the council was negligent.
So you, no. We're just talking about the facts. You are trying to, what? The difference between an express fact and an assumption. Basically, you are trying to infer something from something given to you. So one step ahead. I didn't tell you there was a problem with the lights, did I? All I said that this is what they saw. This is a fact. Green for A, flickering yellow for C. Now you need to use that fact and infer that there must be a problem with these lights. And you have to write that in your answer. This says there was a problem with the lights. Okay. Let's then say that we have the fact that there was problem with the lights. What turns on that? What happens next? There's a problem with the lights. So what?
The people who are responsible for the upkeep of the flats, because they could argue that
So just give me one pair, please.
A versus C.
A versus the council.
Yeah.
Okay. So let's go with A versus council. CN. That's what you're saying? A versus the council.
Other possibilities, there could be multiple people, so it's like, or different parties could.
Okay, let's start with this one. A versus CN. What is the premise here? What does A want? Compensation. And what's the premise? No, that's the fact. Negligence.
Would C work better? Like party C, because they were the one who said that the light would get yellow.
So we said A could go after C. But he could also go after the council.
Yeah.
Both.
Yeah. And then the car C could go after the council as well.
Yeah, car C could go after the council. Now, if I want you to choose between going after C and going after the council, which one would you go after? C or the council? Why? More money. So, now this is very important because, thank you, Mary, because you have always to look, so it's game theory. You have to look at the end result after 1 year or 2 years or 5 years or 10 years sometimes. And all of these legal fees and time and energy and suffering and emotional cost to rider. What are you going to get? If you go after C and C is poor or you know, they don't have money to pay you, what are you doing? You want money or you want punishment? If you want money, you don't go after C. Why would you go after C? Wasting your time going after C. So you just drop that. You go after the council because they have deeper pockets. Now give me more deeper pockets because that's what the lawyer does. You have to go after the deep pockets because you can hit them as hard as you want and no one is going to suffer because they have deep pockets. It's okay. They can take it. Give me deeper pockets, deeper than the council. Who would be deeper pockets than the council? Department of Transport, yeah. Maybe they even have more money. The manufacturer of the lights. Can you go after the manufacturer of the lights? Okay, let's say A wants to go after the manufacturer. Many others would go after the manufacturer. What do you want from the manufacturer? You want money. What is the premise? Negligence? Yeah? So you see, it's an art. You have to actually sit down and think of whom do I go after and what are my chances winning if I go after them. And if we continue doing this, you'll find that you have at least 19 pairs, 19 different lawsuits you can extract out of that. Okay. Manufacturer or the municipality. But you are not going to go after all of them, right? So you'll go back and try to reduce the number of pairs you're going to actually pursue. So if you're after money, your best bets would be the product manufacturer or maybe the municipality. So suing the government is always all right. Okay? No, I'm not saying. Okay. Erase that. We're just saying that suing the government is where probably you can get a better chance of compensation, as opposed to suing or corporations, for example. as opposed to suing an individual. But if you're going for punishment, then probably you'll also go for the individuals. All right. So after we have identified, so nothing like this is going to come in the final exam, all right? So in the final exam, it's going to be straightforward. It's going to be one pair. But you have to think whether it's going to be A versus C or C versus A, for example, that kind of thing. Or both. Because I could have a premise against them, and you have, not defense, a different premise against me. I could sue them in contract, they turn around, and they sue me in tort. So you have to identify the objectives, and all of this is in your head. I don't need you to write any of this, unless maybe you can have one page on the left-hand side of your exam booklet, and you just have a plan to think of what you want to do. Okay? The key is the issues. All of this will lead you to the issues, hopefully. You have to identify what the legal issues are, and always remember, before you identify the legal issues, you have to identify the elements from the premises, and the premises will come again from the objectives. All right. All right. So I think that's our tutorial for today. Remember that the stuff we will cover on Thursday in Springfield is different. We're still covering chapters 1 to 3. There's going to be different questions and different slides. So remember also to have a look at those. Thank you.
So when are they put up?
On Friday.
So they're